We're going to move to the second round now.
6 minutes to the Liberals, 6 minutes to the Conservatives, 6 minutes to the Liberals, 5 minutes to the Conservatives, 3 minutes to the NDP. We're going to start with Mr. Fraser.
Thank you very much, Mr. Chair. Mr. Butts, thank you so much for being here. It's good to see you. I want to say thank you as well for your public service, and I know you commented on others who serve the Canadian government so well, but I think your long career of public service should be duly noted as well, and I want to thank you on behalf of all of us here. I'm wondering if you would be interested in tabling some of the text messages that you referred to in your statement.
So my understanding, and I worked with counsel on all of getting access to all of the documents I needed for this presentation and this conversation. My understanding is that is not my decision to make any longer.
Okay. I want to follow up on a question that Mr. Boissonnault was asking you a moment ago regarding a coordinated effort in the PMO, and your answer was very clear. I just want to ask, did you direct or even encourage anyone in the PMO to try and pressure the former Attorney General to approve a remediation agreement?
Absolutely not. And as I said before, I really don't have an opinion on what decision either the former or the current Attorney General could make, and I should make, and I am quite happy that I am not in their shoes.
And as well, like, to your knowledge, in the close working relationship you had with the Prime Minister, did the Prime Minister ever direct or encourage anyone in the Prime Minister's office to try to pressure the former Attorney General to approve a remediation agreement or anything else with the former Attorney General?
Absolutely not.
I want to turn for a moment to the couple of meetings that you mentioned in your statement. The first one on December 5th, when you had dinner with the former Attorney General at the Chateau Laurier. You had said that, I think November 26th was the date that she had texted you and said that she would like to have a conversation with you, and it was going to take longer than 10 minutes, and then later it got coordinated to be a dinner at the Chateau Laurier. She mentioned in her statement that it was a meeting that you both had wanted. Is that fair to say, or would you say that it was her asking you for the meeting?
Well, I'm not sure they're incompatible statements, to be honest. I certainly responded very quickly, and I always enjoyed meeting with Minister Wilson-Raybould. So it wasn't like she had to drag me to the Chateau Laurier Hotel.
Okay, and you'd mentioned as well that there were a number of items that were, I guess, discussed at that meeting, which would be in the normal course of things with the minister whom you were friends with and had a number of issues that you wanted to go through. SNC-Lavalin came up in a brief discussion near the end of that conversation. Is that your recollection?
Absolutely, yeah.
And when that issue came up, what can you tell us about what was discussed regarding SNC-Lavalin at that meeting?
I covered all that I can recall in my opening statement, Mr. Fraser, and I didn't give it a moment's thought at the time afterward. I just thought, I guess Minister wanted my perspective on that.
And in the conversation, she was the one who brought up that issue?
Correct.
With you? And Mr. Rankin mentioned a moment ago that in her testimony, she said that there was a barrage of people hounding me and my staff, and she wanted to bring that to your attention. You didn't recall that. Do you recall her saying anything regarding anyone inappropriately pressuring her or feeling like she was not being treated fairly with regard to this matter?
No, and I believe that I would have done something immediately about it. I was heading to the airport to meet the Prime Minister to go to the First Minister's meeting in Montreal, and I would have done something about it.
And in the follow-up text messages and communication you had with her afterwards, it seemed as though to I guess corroborate the fact that it was a cordial meeting that you had. It was a nice dinner, and that there was no difficult discussions. Yeah,
Minister Wilson-Raybould and I would have dinner maybe 2, 3, sometimes 4 times a year. And we'd catch up on a whole lot of things. I mean, I learned a tremendous amount from her, and I have a lot of respect for her. This is a very unfortunate series of events.
Was there any briefing that was done with anyone else after the December 5th meeting, from your point of view? Anything related to?
I may
Conversations
have
you had.
mentioned the next day in Montreal that I had suggested, or I usually debrief Katie, Ms. Telford rather, or the clerk maybe. I don't know. I don't have a clear recollection of it, to be honest.
Okay, and it was quoted that you had said that you disliked the law and we need a solution on SNC stuff. And you made comment about that, but that's not the way that you would have characterized that.
No, and I appeal to the firsthand knowledge of the people who have worked with me over the years on very delicate, sensitive matters, including many of you around this table, and ask you whether or not that is in keeping with my character to do such a thing.
Okay, and the Harper era law that you were talking about, or you talked about the fact that there was a director of public prosecutions brought up, and that happened in the time that Stephen Harper was the prime minister. That was the context of that.
Yeah, that's it. It was a chronological point, not a political one.
Okay, thanks very much.
Thank you very much. Ms. Raitt?
Mr. Butts, you said that you reviewed your texts since you have resigned from PMO. How did you still have possession of your government phone?
I acquired the ability to review my texts through my counsel. I do not have possession of my government
You don't have your phone, so you received the access to the phone? Is that what you're saying?
However, my legal counsel got the texts. That's how I got them, through my legal counsel.
So they did a review of records and they produced the texts to you?
I'm not sure what you're asking, Ms. Raitt.
I'm asking how, if you gave up your phone when you left the PMO, that you still had access to the phone to produce the texts today. You said you didn't. You received it from your legal counsel.
That's true.
And I'm asking who then picked the texts that you were to receive and look at.
You may recall there was a small story on the front page of the Globe and Mail about this a few weeks ago. And when that story ran, I said to myself, actually, it wasn't when the story ran, it was the next day, when I got a very specific question from the Globe and Mail through the office directed at me about my meeting with Minister Wilson-Raybould. I believe they were even specific enough to say at the Chateau Laurier Hotel, where my first instinct was to look at my phone and see if I remembered it as correctly as I thought I did.
Okay, talking about the cabinet shuffle, your testimony is it wasn't about SNC-Lavalin. So why was the Deputy Minister of Justice told that why did the Deputy Minister of Justice say that the Prime Minister wanted to talk to the new Attorney General about SNC-Lavalin matter first thing?
I have no idea. You'd have to ask the Deputy Minister of Justice that.
Okay. Do you believe that SNC-Lavalin was entitled to a deferred prosecution agreement?
No, absolutely not.
I'm going to read you a part of the mandate letter. Did you draft the mandate letters for the
No.
for the ministers? Did you have a hand in drafting the mandate letters?
I'm not sure. I think that's a subjective standard. I probably read them before they were sent, but I don't think I...
Right.
Yeah,
Well,
had
one
a heavy
interesting
hand in
piece for me is that the Attorney General of Canada, you are the Chief Law Officer of the Crown, responsible for conducting all litigation for the federal government and for upholding the Constitution, the rule of law, and respect for the independence of the courts. That would seem to be the marching orders for the former Attorney General of Canada.
I would agree with that.
And
yes.
she was discharging her duty during this entire time.
I believe so. I have no reason to believe she wasn't.
Okay. You mentioned a minute ago, Mr. Butts, that Elder Marquez and Mr. Bouchard have a sterling reputation and they would not engage in certain matters of politics. Now, I want to take you through the chronology because what I find interesting is it was consistent how many times attempts were made to either get directly to the Director of Public Prosecutions, which is completely not acceptable. The only connection between the Director of Public Prosecution and the government is through the Attorney General. Would you agree with me on that?
I would agree with that, yes.
So when Ben Chin started negotiating on behalf of SNC-Lavalin, indicating what they were prepared to agree to, as one of the chiefs that report to you, do you find that to be acceptable?
Sorry, could you repeat that?
So Ben Chin, on September 6th, said that SNC's legal counsel was former Supreme Court Justice, and he also indicated that SNC was prepared to agree to certain things in order to get a deferred prosecution agreement. That's the testimony of Jody Wilson-Raybould. If he did that, is that acceptable behavior in your opinion?
I'm not going to answer a conditional question like that because
Well,
I don't
okay.
know if he did it.
So Mr. Bouchard and Mr. Marquez said on September 16th.
But can I say something in response
have a
to your
whole
first?
list of these guys, so you can say it.
I can imagine you do.
Okay.
But about this idea that someone tried to directly interfere with the DPP, on February the 12th, my understanding, when making a public comment on another matter, which is the one I think you were alluding to earlier, which we should not discuss here, my understanding is the DPP said that there had been no political interference in that matter or in any other matter.
Correct. But what I'm talking about, Mr. Butts, are the attempts to be political. And I'll bring you one more. Matthew Bouchard and Elder Marquez said, according to Jody Wilson-Raybould, that the individual Crown prosecutor wants to negotiate an agreement, but the director did not. How would members of your PMO staff have knowledge of what a single Crown prosecutor would know or not know about a DPA?
I have no idea whether or not that is factually correct.
Okay, as well, they indicated that the Deputy Minister of Justice thinks that she can get the Public Prosecution Service of Canada to say that we think we should get outside advice. So that's Prime Minister's office, Justice Minister, Justice Deputy Minister going directly to the Director of Public Prosecutions. Would you agree that that's not acceptable?
I don't believe that they did.
You don't believe that?
That they went
so you don't
directly
believe
to-
the testimony of Jody Wilson-Raybould?
That is not what I'm saying.
Well, this is her testimony, and this is what I'm saying. On September 19th, both again raised the idea of an informal reach out this time to the Director of Public Prosecutions. How is that acceptable as an indication from the Prime Minister's office to suggest an informal reach out from either the Deputy, the AG, or even a member of the Deputy's staff? How is that acceptable when we know the line between Public Prosecution Service and the politics of this country is very clear?
I agree. Can I answer it though, Mr. Chair?
I wanted to let you know that that's
Okay.
the
I agree that it's very clear, and I just want to go back to the substance of my evidence I'm providing here. I think that I don't think I know the people involved. I worked with them closely. I know the file a little bit. It just doesn't ring like something they would do on this or any other matter.
Thank you very much. We're going to Mr. Fraser now.
Thanks very much. Mr. Butts, I just want to pick up where I was earlier and go to now to the meeting of December 18th
Right.
that you had with Kitty Telford and the former Attorney General's Chief of Staff at the time. How commonplace would it be that you would have a meeting with a Chief of Staff regarding an important matter that was of concern at the
Very,
time?
very. We met with chiefs of staff all the time, both together and separately.
Okay. How did that meeting actually come about? Who actually coordinated that meeting?
I don't recall. I mean, it was, as you say, that my answer to your first question, Mr. Fraser, is that it was very commonplace for such meetings to happen. It wouldn't have been unusual. In particular, at that time of year, Ms. Telford and I tried to meet with chiefs of staff at the end of sessions to check in and see how things were going, that kind of thing.
Okay. In her testimony, the former Attorney General had indicated that she had received a text message from her Chief of Staff shortly after the meeting indicating that the meeting was, that she was urgently summoned to the meeting. Does that sound like a fair characterization of your meeting?
I can't think of a single instance in which Ms. Telford and I urgently summoned anyone. But as I said about my dinner with Ms. Wilson-Raybould, people can come away with from the same experience with different impressions. So I have said many times, as I'm sure you've heard me say in caucus at points, Mr. Fraser, that the longer we are all in these jobs, the more people see us as these jobs and not as people. And I think that carries with it a responsibility to be conscious of power dynamics between people. And I like to think, and nobody's perfect, but I like to think that Ms. Telford and I were very conscious of that.
would you say it's fair to characterize that the main tenor of that meeting on December 18th was in order to discuss retaining external counsel to give an opinion about the correctness of a DPA?
I believe that's a fair characterization, but I can't be sure. And I know that the biggest contentious issue that we were discussing with the Minister of Justice and Attorney General's office at that time was the directive on civil litigation matters involving Indigenous people. And there were concerns in different places with different people and different ministries, and most of the discussions that I recall between our office and theirs and hers at that point in time were about that subject. So I'm sure that came up as well.
It was indicated in the text messages from the chief of staff to the former Attorney General that you said that there was no solution here that does not involve some interference. What do you say about that?
Well, I think I answered that question a little while ago, Mr. Fraser, but that is not what I said. I do remember that part of the conversation, and I think this is the this is the heart of the matter here. Does asking for external advice constitute political interference? And I think by any reasonable definition of the term, it does not.
With regard to Katie Telford, you were in the meeting and Katie Telford had indicated about arranging op-eds. And I know you touched on it earlier, but can you expand a little bit on exactly your understanding of that comment that was made?
Yeah, it was. It's not a sophisticated tool in politics to ask your supporters to support you, right? And it's a common practice. It's probably been around as long as there have been op-eds, that whatever position the government is taking or an opposition party is taking, they seek out supporters in the free press.
I want to just return for a moment to your opening statement where you mentioned that there seemed to have been a breakdown in the relationship with the former Attorney General. Can you explain how you arrived at that conclusion and when that happened?
I think, from my perspective, I felt like Ms. Wilson-Raybould and I, for most of the time we worked together, whether going way back to her nomination and the election campaign, which you will all remember was not a smooth sail across a calm sea. I felt like we could generally work things out. And I think in the context of the cabinet shuffle, that became very difficult. And I think that's when trust broke down.
Okay. Thank you very much. Those are my questions.
Thank you very much, Mr. Fraser. We go back to the Conservatives. Ms. Raitt.
Thank you, Mr. Chair. I would like to move a motion, please. That the witness produce all communications, texts, emails, written notes between himself, Jody Wilson-Raybould, Matthew Bouchard, Elder Marquez, Katie Telford, David Lametti, Jessica Prince, Ben Chin, Bill Morneau, and Justin Trudeau.
Do you have it written out anywhere, Ms. Raitt, to be able to?
Only in my BlackBerry.
Can I ask a question? Can you write out? Would you mind writing out the motion and then allowing Mr. Cooper to ask the questions in the rest of your time, and then coming back to the motion when everybody can get a copy, and I'll give you back the time to put
Well, I'm
forward
going
the
to ask
motion?
questions in this round right now, Mr.
Oh, yeah, I'm
Chair,
sorry. I thought Mr.
and
Cooper was asking the
Certainly,
question.
yeah, certainly I'm fine with that. So
Sure,
I'll
sure. Yeah.
continue?
Yeah.
Okay. Mr. Butts, did you know that on September 17th, Jody Wilson-Raybould indicated that she instructed her staff to ensure they had a very detailed chronology of all meetings and conversations about the SNC-Lavalin and deferred prosecution agreements because she was worried about what was going to be happening in the coming months? Were you aware of that?
I was not aware of that, no.
Well, she did, which I found interesting. As we were talking about what the Prime Minister office staff was doing to try to get to the Director of Public Prosecution, the second type of legal opinion that was sought was different, and this time it was a legal opinion sought on the actual director's decision to not grant a deferred prosecution agreement. Were you aware that Mr. Elder and Mr. Bouchard requested that?
I'm not even sure I know what that means, Ms. Wright, to be honest. It
Okay, well-
sounds, you are a lawyer, correct?
I am.
I am not.
These are important issues, Mr. Butts, and because you're testifying here that you are the link between the Prime Minister and the Prime Minister's office, and yet the Prime Minister's staff was clearly over the line of appropriateness. That's testimony from Jody Wilson-Raybould, and that's my assumption based upon the fact that she put forward. So at the end of the day, you are responsible for these matters, and your responsibility flows up to the Prime Minister.
That is correct. I'm also testifying that if anyone crossed a line, it is the responsibility of the minister to inform somebody about that. And I'm presenting myself as the most likely person that would have been informed, and I was not.
So in her testimony, when she indicated that she brought it up with you and said it was inappropriate, your testimony is you don't recall it that way.
My testimony is that I recall a very different conversation, yes.
And that she did not tell you that it was inappropriate for people to continuously ask her about her decision after she had made it?
Well, I think whether or not she made it is the subject of some debate.
Well, let's go back to that.
I will say that if a minister, any minister, especially the Attorney General, spoke to me and said that a member of my staff or any other staff were pressuring them in an inappropriate way on any matter, I would have spoken to that staff.
So let's go back to the Section 13 memo that was written for the Attorney General. For background, when the Director of Public Prosecution determines there's a matter of public interest that she needs to inform the Attorney General, she writes a memo that is only for the Attorney General's eyes personally, does not go to anybody else. And she lines out exactly why she's taking the decision and why it is important. How often did you receive in the Prime Minister's office written instruction from the Attorney General on what she had did or did not do on a Section or Article 13 request from the Director of Public Prosecutions?
I'm not aware of any.
Never. So why would you testify that you thought that she should have provided written commentary or written notice to the Prime Minister's office?
I didn't say she should have provided written commentary on
I think you did in your testimony,
a Section
Mr.
13
Butts.
order. I did not. What I said was that if she had made her mind up on a matter, she did not have to disclose the content of the order. She could have simply informed us that her mind was made up and that any attempt to open the subject with her was inappropriate. And I think that a fair evaluation of the events of the fall suggests that that was not the case, that further meetings were welcomed and solicited, and advice was also welcome.
So your testimony is that on the occasion that the Director of Public Prosecution sends a note to the Attorney General indicating a matter of public interest, that the Attorney General has the obligation to inform the Prime Minister's office of a decision she took, because that's exactly what you just told us.
No, that's not exactly what I just told you. What I told you was that if her mind were made up on the matter, she need not disclose anything about the content of the order. And my understanding is that that would be inappropriate if she did. But if there were ongoing discussions, which she is welcoming, the minister is welcoming, and in some cases soliciting, that it is inconsistent with the supposition that her mind is made up, and it is also inconsistent with our understanding of the law and the way we were briefed on how the law operates, because no verdict had been rendered in the case, and it was possible that new information could come to light. And in fact, not only was it possible, it happened in the case in this case, when the DPP rendered a fresh judgment on October the 9th.
So
Your time on questioning is expired. Do you want to move the motion now? So we have a copy by email, but I don't know if there's a copy that members could get. Did anybody write it down on a paper or anything that members could get distributed?
No, but you can read
We'll read it into the record. Well, it's not that long. Maybe people can do it without a written document. Ms. Raitt, go ahead.
I don't have it in front of me right
Oh,
now.
so Ms. Raitt, would you like me to read what you
have it?
haven't?
Would you read it for me? That would be excellent.
So, yes. So what we have from Ms. Raitt, colleagues, is that the witness produce all communications, texts, emails written notes between himself and the former Attorney General Jody Wilson-Raybould, Matthew Bouchard, Elder Marquez, Katie Telford, David Lametti, Jessica Prince, Ben Chin, Bill Morneau, and Justin Trudeau. Is that correct, Ms. Raitt, as to be your motion?
I'm going to take your word on it, yes. It sounds right. It's
So-
all the players,
so
yes.
may I just make a comment as chair? That in itself would be beyond the scope of what we're doing. I think you mean to add in at the end the words related to the prosecution of SNC-Lavalin. Because that would be the terms, right? Okay, so then it would be receivable. I just also want to clarify with the witness. I believe before when Mr. Fraser asked if the witness could produce certain texts, I believe there was a reason that the witness wanted to advance that he couldn't, which is that he's no longer part of government and
Correct.
he doesn't own these texts, and it's not up to him he can't produce them. Is that correct, Mr. Butts?
That is correct. They are not under my control.
So I think that the words that the witness produces probably also then no longer the right words that the committee asked for perhaps might be the right words. I leave it to you, Ms. Raitt.
Well, the witness is indicating that he can't produce them on his own, but his counsel can certainly ask for it if he wants to. But if you think it's more, look, we want to get to a result at the end of this, and the result is we'd like to have copies of those items since the witness came forward and indicated he had these items. It would be very helpful to see these items. So if I'm in your hands, if you think it's easier for us to go ahead and ask for it in a different way than through the witness, then that would be fine.
Let me check with the clerk. Yep.
You just can.
Thank you very much. So the clerk is suggesting that the words that the witness be replaced by that the office of the Privy Council.
That sounds great. Thank you.
Thank you very much. So then I judge the motion receivable, and then debate. I have Mr. Boissonneau, but Ms. Raitt, do you have anything further to say before I pass it to Mr. Boissonneau?
On the top, I just want to make sure that we're not just capturing only the texts that may come from the government-issued phone, but if there are any texts on personal phones that those, or personal email accounts, that those are captured as well, which is not a PCO function. It's a function of the witness.
In the measure that the government can have access to these communications.
The clerk suggests that to the measure the government could have access to these communications would be the right wording, but I mean, or alternatively, that we simply call for the production and we don't ask anybody specifically to produce them.
That would be fine.
I think we all understand the concept, and we'll get to the right words in the event that concept is accepted. I think that's basic there. That we're asking that the motion is to ask for the production of these text, emails, communications related to SNC-Lavalin between the people mentioned, regardless of whether the device was government or personal.
Yes, thank you.
Thank you. Sorry, so Ms. Raitt, did you wish to speak to your motion, or do you want me to pass it to the next person?
We can pass to the next person. I think it's evident and clear why we'd like to have paper copies of what's been disclosed.
Thank you very much. Mr. Boissonneau.
Mr. Chair, I think we.
Can I say one thing to Ms. Raitt, which may be helpful, Mr. Chair?
Of course, Mr. Butts.
What I can tell you is that all of the information that I have at my disposal about that involve direct correspondence with the former minister about that December 5th meeting, I read entirely into the record. There's not something that I have not. Actually, that's not true. There is one thing, and it's a small personal thing, and it is that Ms. Wilson-Raybould was going to meet someone after our dinner, and she disclosed that to me, and I'm not sure it's appropriate for me to do that, to say. Okay, but
Perfect.
the entirety of the text that I have about the December 5th meeting with Minister Wilson-Raybould are quoted in my long statement.
Thank you. Thank you. So back to Mr. Boissonneau on the motion.
So, Mr. Chair, based on what Mr. Butts has just said, and based on where we ended up in the testimony with Ms. Raybould, I will be voting against Ms. Raitt's motion. Mr. Butts has indicated that he has read the text into the record, and I think that is appropriate for the purposes of this study.
Okay. Further discussion?
I'll just request a recording.
Certainly, Mr. Barrett. So is there any other, but before we do that, I just want to make sure that there's nobody else that has their hand up.
I just want to say something. So the intent and purpose of ensuring that we capture any texts, emails between the witness and the Prime Minister's office staff is because I'm going through right now a chronology where two members of the PMO, according to Jody Wilson-Raybould, were very inappropriate in the way in which they approached her office as the Attorney General. And the witness has indicated that he has no knowledge of it, but that he believes in their sterling reputation, that they would not engage. He is their boss. I would like to see whether or not there are any texts associated with them reporting to him or him giving them direction. I think that is an absolutely reasonable request to be made.
Thank you very much, Ms. Raitt. Any other intervention? Not seeing any. Mr. Barrett has requested a recorded vote. Mr. Barrett? I'm sorry, Mr. Barrett. Mr. Clerk?
If I may
Yep.
I request you to clarify with the committee there is an invitation today?
It's in. This motion is in order, I believe, for production. It is not an invitation to produce, right? And Ms. Raitt, I'll look to you, but I believe that what you intend is that these be produced. Okay. So everybody understands this would be in order to produce these various documents between the individuals listed related to the SNC-Lavalin prosecution. Again, and Mr. Barrett has requested a recorded vote. I'm going to the clerk.
Merci, Monsieur le Président. Alors, Monsieur Boisson.
Thank you, Chair.
Mr. Essasi.
No.
Mr. Fraser. Ms. Khalid.
No.
Mr. McKinnon. Mr. Barrett.
Yes.
Mr. Cooper.
Yes.
Ms. Raitt.
Yes.
And Mr. Rankin.
Yes.
In favor 4, en défaveur 5.
Okay. Donc la proposition a été faite, but
So the motion was defeated.
time is now up. You have 3 minutes on this round, sir.
I'd like to ask Mr. Angus to ask questions.
I'm
on
sorry,
our behalf.
Mr. Angus. Mr. Angus, the floor is yours, sir.
Chair, the question that's been put forward to us by the evidence of Ms. Wilson-Raybould is a concerted campaign of interference in the independence of the Public Prosecution Service by your office. That's the question before us. So her testimony provides us a picture. We have Mr. Marquez and Mr. Bouchard wanting an informal reach out to the prosecutor to go around her. She said that that would be political interference. Ben Chin says it's about the Quebec election, which would be a completely inappropriate thing for someone from your office to say. Bill Morneau, after being lobbied, pushed her and she told him to back off. The clerk of the Privy Council had numerous conversations, one of which she said she was threatened 3 times, including where he said, you don't want to be on the wrong side of this Prime Minister. The Prime Minister said, according to her testimony, that he wanted action because he was the MP for Papineau. Katie Telford, according to Ms. Wilson-Raybould, said she wasn't interested in legalities, and she has you on the record as saying, I don't like the law, it's a Harper law, and then further, that we don't get through this without intervention. So how do you then tell us this was he said, she said, and not a concerted campaign that you were involved in to intervene and override the decisions being taken by the Attorney General of Canada?
Well, excuse me, I think I detailed the reasons why I don't think that was the case. I was present in the office for that time period described, and absolutely no effort to intervene in the independence of the justice system.
But you
occurred.
said to Jess Prince that we don't get through this without interference.
No, I did not say that, and I
So
explained
are
it.
you saying then that Ms. Wilson-Raybould testified? She was very believable to Canadians. You did not agree to go under oath. So the question is she wrong? Did she make that up?
I think I explained at length, Mr. Angus, what I think happened.
No, but I'm not getting an answer here. You may have explained it,
I am
but
not
I don't
gonna- I'm not-
understand. Because
Mr. Angus, with
as you
respect,
say,
with respect,
she
Mr.
either
Angus.
lied or she
Angus,
didn't.
please let the witness finish.
Sorry,
Please let him just finish the answer, and then we'll come back to you. Finish the answer, Mr. Butts.
Mr. Angus,
It's about her credibility,
it is about what happened,
okay?
and there are different perspectives on what happened.
I see.
I am not here to call anybody names, and you will not get me to cast
I'm not asking you
aspersions.
to call someone names. I'm asking whether or not there was interference, because facts, my
No
friend,
is
as
the
you
answer
said,
to that question. No.
facts is are
No is the
very
answer.
stubborn, because I will ask you, then, it's not just her, but Ms. Philpott said, I have lost confidence. I must abide by my ethical and constitutional obligations because of the allegations of interference by your office. There can be a cost to acting on one's principles, but there is a greater cost in abandoning them. So is Ms. Philpott not understanding this either?
I would certainly agree with the last statement, that there is a cost to abiding by one's principles, as is there a cost to abandoning them.
Thank you.
I think that in this case, as I detailed at length, there's more than one way of looking at it.
Thank you very much. That ends the second round. I just would note that the witness did not refuse to be sworn in. The committee voted against swearing him in, as we have voted against swearing in any other witness on these meetings. So